crazy migration. So David we're now recording, but what I'm going to do here momentarily is just stop talking. And that will be sort of a cue to him when he goes back and looks at this. So then I will commence once again. And at the end of the program, uh, I'll say something like, thanks for being with us today. It's been great to chat with you. And then we'll just sit quietly staring into the camera. And then that's his cue to say, I got it. So we're over. Any questions from you? Are we everything set?
Makes sense. No, it makes sense.
One last gulp of water.
Oh yeah, good call.
So let's go do it. Hello again. I'm Chuck Dick, one of the co-chairs of CalArb's programming committee, and I'm delighted today to have another very interesting guest with us as part of our ongoing California Conversations special series of interviews. And today we have a relative newcomer to California, but a man with a very interesting background and a wonderful professional story to share with us. Marco Molina is in the Orange County office of Baker and Hostetler. And I have been delighted to share some time with him, getting to know him a bit better and to find out about his migration to California, and particularly to learn a bit more about his practice and his interest in CalArb. So rather than belaying the point, Marco, welcome to California Conversations. Delighted to have you with us today. And I'd just be interested to kick this off by having you tell us a little bit about this migration I referred to, and how in the world do you travel the world with as many stops as you have and end up in California?
Well, thank you, Chuck. Let me just say it's a pleasure to be here. Yeah, I have sort of a unique story, I think. I was blessed to be to have traveled and lived in different parts of the world. I was born in Italy. My first language is Italian. I then moved to Venezuela when I was young with my family. Learned Spanish. Have a Venezuelan father, a Mexican mother. So we also ended up in Mexico for a little bit, and then ended up in Akron, Ohio when I was 7 years old, of all places, because my dad worked at Goodyear, which is based in Akron. So I just remember as a kid going from Italy to the tropical beaches in Venezuela to Mexico City and then to Akron, Ohio, which is actually a lovely place to grow up. And I was there for several years. Went to college in Ohio, and then ended up at NYU Law School. And that's where I sort of started my first chapter of my career. After graduating from NYU Law, I worked at another law firm and then jumped onto the Baker Hostetler train about 13 years ago now, to take on the challenges that came with the Bernard Madoff litigation, which was the hot case in town at that time, and still ongoing today, believe it or not. And over time, lived in New York. Thought I would be a Manhattan person most of my life, but then the lovely woman that I'm married to told me in not so many words that she was tired of the New York winters and that it was time to go back to her roots in Southern California. So I in my mid to late 30s, with in the middle of a pandemic and with a long caseload of work, I had to take bar exam lessons. After dinner, I would study 3 to 4 hours into the late night, and took the California bar exam, passed it, and here I am. So this has been now about 3 or so years since I've been here, and couldn't be happier and excited to be here today. Well, I think you're on mute, Chuck. I'm sorry.
Yes, forgive me. There was some noise in the background. I'm sorry about that mute button. As I mentioned earlier, though, I was delighted in getting to know you, and we were really pleased to welcome you to California, to have you part of our California bar. You bring some luster to what we're trying to do with CalArb, and I'd like to go back, though, because you mentioned Bernie Madoff. That's a fascinating chapter in American financial history. And I don't know whether you've got any anecdotes that you can share with us about that, but some of the things you learned from your work on that project might be of interest.
Absolutely. It's been, one of the defining cases of my career for sure, and one of the defining cases, I think in American jurisprudence, because if you think about it, first of all, it was the largest financial fraud in history, in recorded history. We're talking of at least $20 billion of capital, investment capital that was misappropriated. And it wasn't just by Mr. Madoff, but he had associates, he had institutions that facilitated this fraud. And so when we walked to the offices of Bernard Madoff, and we had to figure out how do we remediate this fraud, because our firm and one of our partners was appointed as the trustee to oversee the liquidation process and get the victims as much money as they back. And we realized we're talking about a multi-decade fraud that spanned dozens of countries, and by that I mean that the assets in question had been misappropriated throughout the world. And one of the things that I've been working on from day one and continue to work on to this day in that case is helping the trustee find and recover missing assets that were spread outside of the U.S. So so through that, I sort of was my first foray into international disputes, because a lot of it entailed working with local counsel at a foreign jurisdiction, working with prosecutors, courts to freeze assets and then ultimately recover them for distribution to the victims. And to date, I'm happy to say we've recovered, I think, approximately 14 billion of the just under 20 billion that had been stolen. And so we're still going. So it's been a fascinating case. As far as the anecdote, I mean, what I can tell you is I remember I walked in the door at Baker as a young attorney, and they told me, you seem to have an international background. We want to put you on the international components here. And I thought, oh, great. And I thought that meant they would put me on maybe Latin American stuff or a thing, or Italy or something where my cultural background would sort of fit. But I think the first few cases I had, they were mainly focused in Austria, Liechtenstein, Switzerland. And of course I speak no German, and it was sort of a learning curve, right? Where you're working with all these amazing people in these parts of the world, and there's cultural barriers, language barriers, but it was all the more satisfying when we're able to achieve great results. And it opened my eyes into what it's like to work in litigations and cases that have a multinational component. And I think in many ways it paved my interest in what I do now, which is almost entirely focused on international disputes, particularly international arbitration.
Well, you were anticipating my very next question because you come from a sort of a traditional litigation background, but I know that you have migrated with your practice into the areas that include arbitration, and maybe some of the experiences you've had comparing and contrasting that with the arbitration forum would be of interest as well.
Yeah, I mean, it is, it's funny because in many ways it's similar, but in many ways it's extremely different than U.S. litigation. I mean, at bottom, I think we in the U.S. I think are lucky and blessed because in our jurisprudence and our legal system, we're taught how to present argument orally, how to depose somebody, how to cross-examine somebody, how to elicit witness testimony from your witness, how to present oral argument in an opening or in a closing. These are things that are sort of incumbent and part and parcel of our American jurisprudence. And I think that in many parts of the world, particularly civil law countries, they don't have that. Almost everything is argued in writing. And so what I've learned is that in many ways it's similar, and it's helpful for me to have this U.S. litigation background with international arbitration, because I'm a lot of the things that we do there, and as you know, with any arbitration, whether it's domestic or international, it all culminates in this hearing, a final hearing, where you have to present your argument, and you have to do so through presentations, through testimony, and through closing and an opening. And a lot of that has been very helpful, and I think has been useful. But it's a completely different ballgame. You're dealing with, especially in international arbitration, you're dealing with witnesses co-counsel, adverse counsel, and tribunal members who are from different cultural backgrounds, who have different experiences than you have. And a lot of it, and you're dealing with different, it's not just one body of law. Oftentimes, I mean, in some international arbitration cases, I'm dealing with 2 or 3 different bodies of law, and you're trying to make it all fit together and to tell a concise and persuasive story. And it's a challenge, but it's a challenge that I relish, because it's I think the more complex, the more interesting that a case is. And I think that's one of the many things that has surprised me about international arbitration in the last 8 years or so that I've been focusing on it, and it's one of the most rewarding things about it.
Today, does your practice have any particular geographic emphasis?
It does. It does. I am so because of the background that I gave you, I tend to have most of my clients and a lot of my cases focus on the Latin American region, and I'm including with that Mexico all the way to to South America, and anything in between. So I do have that expertise, and a lot of it, this is another thing about international arbitration, especially now that it's becoming more and more commonplace, is that even if your clients speak English perfect, even if you're able to communicate seamlessly, there's something to be said from a client's perspective to have counsel that gets them, that understands the cultural nuances and understands the way things work outside of the U.S. and specifically where they're from. And so it's not just a matter of speaking the same language. It's a matter of having a similar set of experiences and values. And so for that reason, I found that it's been useful to draw from my experience. I speak 3 languages. Spanish is a language that my wife jokes with me, because she says, it used to be that when you practice and I walked by, your office, it would be in English, but now almost everything you do is in Spanish. And it's true, because even though I could speak in English with my clients or my colleagues, I think that it's so to answer your question, that's why Latin America has been a focus. But that being said, as you know, Chuck, we're at the whim of our clients, and sometimes our clients have cases that take us to Liechtenstein, like where I was a few years ago, and even if you never thought you'd end up there. So a lot of it is we're in a service industry where we're servicing our clients, and sometimes we find ourselves in different jurisdictions. But I'd say my focus has been primarily in Latin America.
Well, there's another facet of your arbitration practice that I'd like to pursue, because I know you have a significant experience doing investor state arbitration. And I know that many of the people who view California Conversations would love to know a bit more about that, and how you got involved in that particular branch of commercial arbitration.
Well, yeah, that's a great question, Chuck. And I agree with you. It's one of the, it's sort of a niche practice, I would say, and it's become more commonplace, but it's always sort of been not. When you think of international arbitration, like domestic arbitration, you think of commercial cases. You have a contract that has an arbitration clause, and now you're dealing with a dispute. Investor state cases, and I'm going to just give a brief summary of what they are, just for anyone listening. Investor state cases occur when you have, instead of a contract in a commercial context, you have an investment treaty or agreement between states. And this is important because typically, if you want to sue a state, there's a thing called sovereign immunity. You're not able to bring a case against the state. But what makes these investment treaties and agreements somewhat interesting is that the states themselves waive their sovereign immunity and say, I will let you sue me, provided that we enter into this agreement where you let me say it differently. I will let you sue me as an incentive for individuals in your country to come invest in my country, right? So please come invest in our country, and in return, we will give you certain protections. And if we don't meet those protections, you will have a right of action, right? So that's what those investment treaties and agreements offer. And so the way these disputes and these arbitrations ultimately play out is you have, let's say there's a treaty between the US and Peru that has a bilateral obligation where each side is going to incentivize the nationals of the other side to come invest in their country in return for these protections and ultimately a right of action if the protections are not met. A U.S. investor that invests under that treaty in Peru, if that investment does not, something happens to that investment, the U.S. national can bring and will bring a litigation, an arbitration under this investment treaty, and that's what investor state arbitration. How I ended up doing this sort of work. It's I give a lot of credit to the head of our practice, Mark Simrod. He's somebody that in the 90s and the early 2000s was working on these sorts of disputes. So also, we have another partner in our office, Ken Reisenfeld, who has also very, very unique experience, and it goes back to the early 2000s. And that's how, so because they brought in this experience, I was able to sort of get a sneak peek into it and ultimately get the opportunity to work with these individuals and others in our practice area. And it is, of all the international arbitration matters, those are in many ways the highest stakes. I mean, I've been blessed and lucky enough to represent both investors and states in these sort of disputes. And when you're dealing with a state, you're dealing with their ministers, the top lawyers within the government. Everything that you do and all the things that are at stake can affect an entire country. And so there's a lot of considerations that have to be. It's not your typical case where you're dealing with just one client. You're dealing with the whole government. And then conversely, when you're on the other side of it, the ramifications of the case you're bringing against the state, they could really have a ripple effect. I mean, if there's an award from an investor state tribunal that says that a certain country's policy is violation of international law, that could lead to numerous other arbitrations, and it could lead to the termination of a policy or the amendment of a policy that could have wide-ranging implications. So the stakes are higher, I would say. It's not so much because of the dollar value, but more because of all the other considerations at play.
Well, you've given us some idea of the differences in your practice between traditional commercial arbitration and investor state arbitration. I wonder if you could say, I prefer to do one or the other. Why would that be the case?
I don't think I prefer to do one versus the other. They are different, though. At the end of the day, again, not to repeat myself, at the end of the day, when you're dealing with commercial arbitration, at the end of the day, you're really dealing with money, right? You're dealing with some sort of commercial transaction. And with the investor state, it does feel the stakes are higher than just money. That being said, they both have the same components. For both, you're dealing with the same amount or similar amounts of pleadings, the similar type of discovery, and a similar sort of final hearing that you're building up towards. So as far as the practice part of it, I enjoy doing both because they're both so similar. But I will say that when I work on an investor state case, you can definitely feel that it's just a little bit higher stake.
Some of our listeners, I'm sure, Marco, would say, you're sitting out here in Southern California, more specifically in Orange County. That doesn't sound like a hotbed or center of international investor state arbitration. And yet you've got a thriving practice, and maybe you've got some lessons you could share with those who are listening and who might be interested in following your footsteps.
It's funny you say that, Chuck. I joke with people here that, in some ways, California is the Wild West of international arbitration, right? Or it's sort of the frontier that's yet to be sort of overtaken. Here's the reality, Chuck. International arbitration 20 years ago was sort of a niche practice. It wasn't something you saw every day. Nowadays, every major law firm has a international arbitration practice. It's commonplace because we live in a world today where every company is dealing with multinational clients, has service providers in other countries. Every country is entering into agreements that have international arbitration disputes, not just domestic arbitration, but international arbitration dispute clauses. Again, like I mentioned, because the investments in under today's climate, people are investing across the world. Now you have these investment treaties that become very, very important and become the subject of litigation. I think that what maybe in California used to be difficult and for many reasons, but one of the reasons it used to be difficult to have international arbitration practices here is because of the unauthorized practice of law statute, which was interpreted in some ways to mean that if you're not barred here, you can't practice here. So if you typically could do, if you're an international arbitration practitioner that could that could be in New York or in DC and practice in an international arbitration proceeding, it might have been different for them in California, but that has now been relaxed to some degree. And I think we are seeing more and more. And I think California is just I think in 10 years, Chuck, if we have this conversation again, the climate will have changed, because I see California, not only is California one of the most important states in the United States as far as commerce, but importantly, it's on the coast. It's dealing with Mexican, entities to the south, Asian countries to its west. It's obvious. It's a place where you have multinational companies that are based, whether it's in San Francisco, LA, or Southern California, and I think that in many ways, one of the reasons why, and I joked that my wife brought me here because of the weather, but one of the reasons why I really was excited to come to California, why I am excited to be here, is because I see institutions like your institution. I see, my colleagues that are based here. I see a lot of potential, and I think a lot of clients here are gonna require more and more of this type of service and this type of practice as time goes on.
Well, that's an interesting observation because there's a certain circular aspect to all of this. The more talent we have in California, the more attractive California becomes. The more attractive it becomes, the more business there is. The more business there is, the more talent that is attracted. And so having people like you as part of our stable of talent within California, I think redounds to the future of and benefits us all. So we're delighted to have you here, and you've assembled an interesting team around you in Orange County. How'd you go about doing that?
I'm blessed with a really good law firm, with really good support system, really good leaders, really good management that have given me the tools that I need. Whenever I needed somebody to be hired, or whenever we have certain void that we need to fill. As I mentioned earlier, a lot of this is cultural. It does matter to have members of your team that maybe have different cultural nexus than maybe others. So we have people here in our practice that come from different parts of the world. Some of them are licensed to practice outside of the U.S. So it's been basically strategic growth, not just growing for the sake of growing, but growing in a manner strategic. And in the few years that I've been here in California, we've been able to do that here in our offices in California. And I'm really excited about not only the work that we've been doing recently, but the work that's gonna come down, because as you said, with more talent comes more opportunities.
I know that you have been involved in your firm's pro bono initiatives, and I'd like to talk a little bit about that because some law firms embrace the concept of pro bono. Others are maybe pay more lip service to the idea. That's not true with your firm, and I'd be interested in knowing your personal experiences, particularly in working with the Dreamers.
It's been one of the honors of my career. During President Obama's administration, he passed through an executive order the Dreamer program, or the DACA program, as it was known, as it is known. Which I have a history of migration, as I indicated. We came here when I was younger to work because my dad worked at Goodyear, and we were able to come here. And what DACA did is it gave a similar opportunity for younger individuals and sons and daughters of migrants that came from Mexico or other parts of the world to be able to have a visa, a temporary visa, to be able to stay and work legally and lawfully in the United States. Over as that process, the problem so far that with that program is that I think it was always intended for Congress at some point to make it into a law, so that it would just be it wouldn't be done through executive order. But to date, we haven't had the pleasure of, there have been bills that have been proposed by committees, and so far nothing's taken place. So what we've done is, we partnered with nonprofit organizations in Mexico that would have access to some of these individuals, and that could reach out to us on a confidential basis to say, we think we either we apply, we meet the certificate, the requirements for this visa, and we'd like you to help us apply and make sure we get this permit, or I have this permit, I need to keep renewing it because so far there isn't a sort of a permanent solution. So it's been an honor and a pleasure, and it's something that, as you said, we're all busy, we all have clients that are demanding, and we also have our personal lives. But I think it's very important to give back, not just in a pro bono basis, but specifically for me, it's been a pleasure to give back to a community of which I find that I belong. An immigrant community from Latin America in the United States, who are doing their best to work and study and achieve their version of the American dream.
Well, you're singing my song. I mean, I have always believed myself that being privileged to practice law carries with it certain responsibilities. It's not a right that we have to do this work. The people have given us the opportunity to work with the understanding that we're going to be, as part of our professional life, having a commitment to improving the Commonwealth. And I compliment you for what you're doing here. Really, it's very impressive, and certainly I know your heart's dedicated to this kind of work. So I can't resist paying a little tribute to you for the good work that you've done. Well, Marco, we're really delighted to have you and your team here in California, and more importantly, delighted to have them involved in CalArb. Many of your colleagues have already raised their hand and gotten involved in the committee work, particularly participating in preparations for California's upcoming International Arbitration Week in 2024. So thank you for taking the time today to share with us a little bit about your background and your practice. We welcome you to California and wish you the very best.
Thank you, Chuck. It's been a pleasure to talk to you. I look forward to having many conversations with you, and to continue to be a member of this amazing institution that you have. So thank you for the opportunity.
And cut. Thanks, guys.
Well, right. Sorry for that mute, but for some reason, in fact, a fire truck just went by, and I thought, my Lord. Well, that's the consequences of urban living.
No worries. I really appreciate everything, Chuck and David, and the opportunity. And sorry about my scheduling issues, but I appreciate your patience.